Man, I found some gold, y'all. I'm gonna keep hitting this thing in their head until everybody gets it. What's going on when it comes to these courts, when it comes to our children, and what they're doing. I'm about to really reveal. Like, y'all might want to look this up, right? Senate Bill 60. I don't know if y'all's state has a Senate Bill 64, and if they do, I don't know if they talk about what this one's talking about. This one's talking specifically, it says a bill to be enacted and enact. Yours is probably going to say the same thing in your state. However, I'm going to show you, I'm going to read in here in detail what they do when it comes to the children. But I'm going to skip around a little bit because I read this whole thing and I want to really get to the real part of it, that where they confuse us. Now, first off, I'm gonna show y'all. I'm in Georgia, y'all, so I gotta show y'all my state laws, what I'm talking about. So, here we go. It's not one. It's not this one. It's actually 131. So I'm gonna go back one. Right here. I'm gonna go back to this because we gotta get this part. Let me make this bigger. Okay. Make it a little bit bigger so y'all can get this right here. Keep in mind the problem with what's going on in these courts. This is the root of the problem right here. The fact that they do not determine that they do not how can I say, they don't define the words that they use in their paperwork, and they use legalese to confuse us. And by law, you should look in your law. Make sure you look in your laws. Just look up like construction of statutes and put, like, say if you live in Texas, put in your Google search like construction of statutes Texas or something like that. Construction of statutes Florida, whatever, North Carolina, wherever you live at. Google that and find the statutes where it talks about it. Most likely going to be at the beginning because this is the first chapter. This Title 1 right here, the very beginning right here. Construction of statutes. I'm going to read you. I'm just going to start right here. Okay, I'm gonna read these three right here, A, B, and C. In all interpretation of statute, the court shall look diligently for the intention of the General Assembly. Everybody got General Assembly in this state, keeping in views at all times the old law, the evil, and the remedy. Grammatical error shall not alleviate the law. A transposition of words and clauses may be resorted to when a sentence or a clause is without meaning as it stands. Okay, right here in B, in all interpretation of statutes, and the ordinary signification shall be applied to all words except words of art or words connected with a particular trade or subject matter, which shall have signification attached to them by the experts in such trade or with reference to such subject matter. They supposed to have signification attached to it. Signification is something that actually, just so y'all get what I'm talking about, signification. Signification. Sufficiently great, is it great or important, is a word noteworthy, having a particular meaning or indicative of something. Basically telling you what the hell it means. Okay? Now, and see, like I say, if they right here in this thing right here, say the ordinary signification shall be applied to, to all the statutes, meaning that the ordinary, you're supposed to, when you read these statutes, not all of the words are trick words. Because a lot of times y'all may see, male, or y'all see persons, and you'll see, or United States, and you'll run to one, you'll only remember that one definition you read in a total different statute, a total different title on another piece of material, and you will use that definition to make it and apply it to this what you're reading. And that's not, and it's telling you right here, in all interpretation of statute, the ordinary signification shall apply to all words except words of art, words connected with a particular trade or subject matter. So when words of art, in case you don't understand, an example of words of art would be, say, if you're in the military and somebody's say somebody on a walkie-talkie or whatever, and they're saying, "What's your 20?" and be like that's words of art according to that trade, because they be like, what that means, what's your location, where are you located? But someone who's not in the military, I've never been in the military, but I know that's what they do. So I just happen to know that. So that's one example. So another example, when they say best interest of the child, they use that all the time in child support court, family court. They use best interest of the child. That's words of art. What the hell do you mean by that? What do you mean by that? What do you mean by putative father? What is that? Like they use words that mean something totally different, and they say and subject matter, and they talk about a particular subject that they're talking about. And they use certain terms that mean something based. That's the kind of words the kind of language they use during that subject when they talking about that particular subject. Same thing with a particular trade or whatever, trade or subject matter. So anytime they're using these words, they're supposed to have a signification, shall have signification attached to them by the experts in the trade. So these attorneys they use these words all the damn time. They're considered experts. They've been doing this shit for years. They've been using this. They've been doing it for years. They are considered experts. So they should have a signification attached to their paperwork. Part C says a substantial compliance with any statutory requirement, especially on the part of public officers, shall be deemed held sufficient. That's if they comply with it. A substantial compliance. That means they have a signification attached to their words. Then it's deemed held sufficient. It's deemed as held sufficient. And no proceeding shall be declared void for want of such compliance, unless expressly so provided by law. Expressly, you know what it means to express something. You never said nothing about it, so they get away with it. So that's why they get away with this stuff. So you can't void anything unless that's why you don't never raise no objection to that. They supposed to have significations attached to their paperwork, letting you know how can there be a meeting of the minds if they don't clarify what words they use. Okay, so they can't be he agreed, he applied, he agreed, he admitted to this, admitted to that, and now so we can move forward. You know damn well they didn't know what the fuck they were talking about. You use words of art that was interpreted one way when it meant another way. That leads me to this, what I'm gonna read right here. There's a lot of word magic that's been going on when it comes to this stuff, and I wish I'd been stuck on state statutes and reading state laws, years ago, way in the beginning, instead of being deterred from reading state laws, because they, keep in mind, acts are also laws, you know what I'm saying? Statutes, this stuff is all in there too. But I like how this is broken down in details. You'll see it. Just keep going. To amend Code Section 1511-2, Title 19 of Chapter 10, and Chapter 10 of Title 31 of OCGA. That's what that means, OCGA. When y'all hear me saying a Georgia code, that's what that stands for, Official Code of Georgia Annotated. But I'm gonna say OCGA anytime I see it. Relating to the definitions for juvenile code, domestic relations, and vital records, respectively, so as to repeal voluntary acknowledgement of legitimation. See, to repeal means to annul, you know what I'm saying, or revoke. As to repeal voluntary acknowledgement of legitimation, to provide for comfort and cross-reference references relating to the elimination of administrative look at this here. Say to provide for conforming cross-references relating to the elimination of administrative legitimation. What is administrative legitimation? See, that lets you know there's a different type, there's more than one type of legitimation. Okay, just follow, put that in the back of your head. They talking about administrative legitimation. Okay, and administrative deals with the fiction. It deals with your legal name. Okay, that's why judges can't be a part of a child support court. That's also in the child support manual. I don't know if y'all ever saw that before. I showed that to y'all in a previous video. But a child support family court, when it comes to those things, They can't be administered. They can't be presided over by a judge of the court. Now, because they're administrative. Okay, to provide for and revise definitions to clarify. See, they never revise definitions. Anyway, to clarify provisions related to judicial petitions and for legitimation. See how they talk about this here? They got administrative legitimation. Then it says to clarify provisions related to judicial petitions for legitimation. And lets you know it's two different types of legitimation. They got administrative and they got judicial. Judicial is where there is a judge. It's actually a judge in the court. It's a real judge. Okay. Now, and pause and look up the word judicial. Let me just do that because some people just like they don't want to look up nothing. They want to say, "Oh, the judicial ain't no real judges." So y'all gotta stop regurgitating shit and start looking up words. Okay. Judicial is a descriptive term used to indicate that a thing refers, relates, or pertains to a judge or the court. Okay. For example, these are here: administrator, whatever. Let y'all read that on your own. Pause it, whatever. I don't want to lose my rhythm. Here we go. Anyway, but let you know, it's got two different types right here: administrative legitimation and judicial petition for legitimation. Keep in mind, a petition can only be done by a living man, okay? Because it's sworn. It's sworn and notarized. Okay, you literally got to show up somewhere and show who you are, and they can actually notarize your stuff, and you're swearing or affirming your document. Okay, it's like a sworn testimony, sort of like an affidavit, but you're actually trying to get the courts to do something for you. But anyway, or it's a grievance under sworn. Anyway, it's sworn to provide for witnesses to sign to the signing of acknowledgement of paternity, to provide for access to sign acknowledgments of paternity and voluntary acknowledgement of legitimation. Now, anyway, let's keep going. To change the provisions related to hospital programs for establishing paternity. They need to change that because I did that already, and I did the paternity acknowledgement form, but that's all. I didn't know that's all it was limited to. It's just me being on the birth certificate. Had nothing to do with my rights to my son. None at all. To provide for a savings clause, to provide for related matters, to repeal conflicting laws. That's going to speak volumes to you as you continue to keep going right here, because they got they're actually like two different jurisdictions going on when y'all are in court. You're operating, trying to argue as a living man perspective concerning your baby, talking about what you're doing for your child and how you're spending time with your kid and all the different stuff. We're using these emotional arguments when the whole court case is all about administrative. It's only dealing with your legal name. And that goes back to the law, that there was the signification being attached. So they don't reveal that to you while you're in court. And that's why you should be raising concerns on that. Anyway, let's keep going. Let's see, and for other purposes. Okay, let's go. Code section 1511.2 of the OCGA relating to the definition for juvenile code. So as amended by revising paragraph 43 as follows. Now notice how they say right here, a legal father. It's the difference between a legal father and a biological father. Okay, legal father is only dealing with your legal name. Okay, legal father means a male who has, and don't worry about the word male, because somebody commented on my video one day about a week or so ago saying, what kind of male they talking about? Y'all read right here. In interpretation of the statutes, their ordinary signification shall apply to all words except words of art, whatever. So you reading this here, you don't see no definition where they describing what a male is. So we're gonna go with the ordinary interpretation, okay? So let's not confuse and over complicate these things. We do that, we've been doing this for years, and that's why we ain't getting a lot of remedy. Okay, legal father means a male who has not surrendered or had terminated his rights to the child, and who has legally adopted such child, was married to the biological mother. Notice they don't say legal mother, they say the biological mother of such child at the time such child was born, or within the usual time of gestation, unless paternity was disproved by a court by a final order pursuant to Article 3 of Chapter 7 of Title 19. Or C, married the legal mother of the child of such child after such child was born, and recognized such child as his own, unless paternity was disproved by a final order pursuant to Article 3, Chapter 7 of Title 19, or has legitimated such child by final order pursuant to Code Section 19722. Now y'all can look those code up on your own if you in Georgia, look that up on your own, okay, at your leisure. But you see, when you do legitimation, not only do they see you as the biological father, but they'll also see you as the legal father as well, okay? But yo, as we keep going, you're gonna learn a lot of y'all that do the paternity acknowledgement form. They only see you as a putative father. They use these different titles as they just don't always use those terms in their paperwork. They say what type of father they're saying you are when they drag your ass in the court. They don't tell you what status do you have here. Okay, now keep going. Title 19 OCGA relating to domestic relations is amended by appealing in its entirety Code Section 19721.1 related to acknowledgement of legitimation. Oh, they repealed that one. Okay. I've seen that wordplay in somebody else's state. I can't remember where I saw that. Acknowledgement of legitimation. So they say they repealed that code. They repealed it. Okay, said title is further amended by revising Code Section 19722 relating to the petition for legitimation of a child. Okay, requirements. Therefore, this is what you have to do right here if you want to exercise some rights. Okay. Therefore, the effect of such claims for custody or visitation and third party actions for legitimation as follows. See this right here. You have to do this here, as I said in previous videos, in order to talk about having custody or visitation and having any kind of rights to that. You got to do a petition for legitimation of a child. Now, 19722. Now watch this here. As used in this code section, the term biological father means a male who impregnated the biological mother. See, they don't notice they're not saying the legal mother. Say the biological mother resulting in the birth of a child. Okay, a legal father means the male who has not surrendered or had terminated his rights to the said child. It's the same thing we read earlier. Okay. And say has legitimated such child pursuant to this code section. So once you do the legitimation, you get the genetic testing and get it done. Now you're gonna be seen as the legal and the biological father. Notice that, because has legitimated the child pursuant to this section. So you legitimated the child. Now you'll be seen as the legal and the biological. Whereas before, was the legal father legitimated such child according to this code right here. When you go back and read that code, you'll see exactly what it's talking about. But bottom line, you gotta legitimate the child. You'll be seen as the legal. If you haven't legitimated the child, they don't even see you as a legal father. So if you haven't even done this here, they probably don't even see you as a legal father. They see you as a putative father. So right now, that status they've been having me for all these years. They've been having me not even really as a legal father for real, because I hadn't done it. Well, I didn't surrender my rights. I didn't surrender nothing. I didn't have them terminated. I didn't adopt them. I wasn't married to her. These don't apply, and I had not done this. So let's see a male who has not surrendered or had terminated his right. This is the only thing that applied to me concerning this thing right here. You know what I'm saying? And so right now they don't even see me as a legal father. You know what I'm saying? See me as a putative father. Anyway, let's keep going. So I have to have legitimation done in order to even be seen as a legal father, legal and biological father. Okay, section 2, Title 19 OCGA related to domestic relations is amended. Did I say this already? Oh yeah, I did. Okay, here we go. Down to the biological father. And I already said this here. Now, so, yes, this is what I just read. Now let's keep going. The biological father of a child born out of wedlock may render his relationship with a child legitimate by petitioning the superior court of the county of the residence of the child's mother or other party having legal custody or guardianship of the child, provided, however, if the mother or other party having legal custody or guardianship of the child resides outside this state or cannot, after due diligence, be found within this state. The petition may be filed in the county of the biological father's residence or the county of the child's residence. Say if a petition for the adoption of the child is pending, and the biological father shall file the petition for legitimation in the county in which the adoption petition is filed. So that's somebody trying to adopt your child or whatever, and you want to file for a petition for legitimation. You do it where the child is at. So if you know where the child is at. So if not, you can do it in your own county. Anyway, 60. Okay, a legitimation petition shall set forth the name, sex, and name, age, and sex of the child, the name of the mother, and the biological father. If the biological father desires the name of the child to be changed, a new name. Say the new name. If the mother is alive, she shall be named as a party and shall be served and provided an opportunity to be heard in other civil actions, as in other civil actions under Chapter 11, 9, and of Title 9, the Georgia Civil Practice Act. If there is a legal father, that's somebody that probably would have took on the adoption, like married the mama or whatever, and decided to adopt a child, who is not the biological father, he shall be named as a party and shall be served and provided an opportunity to be heard in a civil action under Chapter 11 of Title 9 of Georgia Civil Practice Act. So even if somebody, a stepdaddy, trying to adopt your child, you can say they're gonna get served too, because you're trying to get your rights. So you're trying to get your rights restored. Okay, upon the presentation of a file of presentation and filing of a legitimation petition, and after the hearing, the court may issue an order declaring the biological father's relationship with the child to be legitimate, provided that such order is in the best interest of the child. If such order is issued, the biological father and the child shall be capable of inheriting from each other in the same manner as if born in a lawful wedlock. Such order shall specify the name by which the child shall be known. A legitimation petition may be filed pursuant to Code Section 151111 in juvenile court in the county in which the dependency proceeding regarding the child is pending, provided, however, that if either parent has demanded a jury trial as to support that issue of the case shall be transferred to Superior Court for a jury trial. Such petition shall contain the same information and require the same service and opportunity to be heard as set forth in subsection C of this code section. After a hearing, the juvenile court may issue the same order as set forth in subsection D of this code section. Now a superior court shall, upon notice to the mother, establish such duty to the biological father. So, let me read this again. A superior court shall, upon notice to the mother, establish such a duty as the biological father may have to support the child, considering the facts and circumstances of the mother's obligation of support and the needs of the child as provided under Code Section 19, 6, and 15. So it sounds like the shit starts to even up at that point. Now, a legitimation petition may also include claims for visitation, parenting time, and custody. So I guess, once you put in a petition, you can actually mention those things in your petition is what you want. What are you looking for? Say, after such claims are raised in the legitimation action, the court may order in addition to legitimation, visitation, parenting time, or custody based on the best interests of the child standard. Say, in a case involving allegations of family violence, the provision of paragraph 4, subsection A of Code Section 19, 9, and 3 shall also apply. H. Let's see. In any petition to establish paternity pursuant to paragraph 4 of subsection A of Code Section 19,743, the alleged biological father's response may assert a third party action for the legitimation of the child born out of wedlock if the alleged biological father is in fact the biological father. See, upon determination of paternity, or if a voluntary acknowledgement of paternity has been made and has not been rescinded pursuant to Code Section 19,746.1, the court or trier of fact, as a matter of law and pursuant to the provisions of Code Section 19,751, may enter in order or decree legitimating the child born out of wedlock, provided that such is in the best interest of the child. See, this is a part of what I was talking about. I was talking about words of art. They use this all the time. The best interest of the child. They always say that. So, anyway, that's an example of words of art. Okay, because you only hear about that when you in family court. You never hear that on the streets. You never hear that in your private life. You don't hear that, nobody huddling around, sitting around talking. They don't say that. Okay, we use other words. Okay, that we use plain English, not words of art. Let's see. Not when it comes to that. In determining the best interest of the child, the court should ensure that the petitioning alleged biological father is in fact the biological father, and may order the mother, the alleged father, and the child to submit to genetic testing in accordance with Code Section 19,745. Whenever a petition to establish paternity of a child is brought by the Department of Human Services, issues of name change, visitation, and custody shall not be determined by the court until such time as a separate petition is filed by one of the parents by the legal guardian of the child, in accordance with Code Section 1911(8). If the petition to establish paternity is brought by a party other than the Department of Human Services, or if the alleged biological father seeks legitimation, the court may determine issues of name change, visitation, and custody in accordance with subsection C and G of this code section. Custody of the child shall remain in the mother unless or until the court order is entered addressing the issue of custody. Okay, I wanted to stop and say something, but I took off on this stuff right here. But anyway, we're gonna keep going. If it comes to me, I'll stop. Okay, said title. What was I gonna say? Never mind, because it's gonna come back full circle anyway. Said title is further amended by revising Code Section 19,725 relating to in whom parental power over the child born out of wedlock lies as follows. I read this, and this is what actually was the kicker that showed exactly why I haven't been able to have access to my son all these years. Only the mother of a child born out of wedlock is entitled to custody of the child unless the father legitimates the child, as provided in Code Section 19:722. Otherwise, the mother may exercise all parental power over the child. That was my problem the whole damn time. And if I wasn't against statutes all these damn years, because I've been taught on the internet, listening to other people saying statutes are not laws. And then you don't read your statutes, and so you wonder why you're getting railroaded, because they tell you exactly what the fuck you're supposed to be doing. But if you don't want to read it, keep on goddamn listening to these damn assholes on the internet telling you statutes are not laws, and you don't want to read the definition of a statute, and the first thing it tells you that they are laws. But anyway, keep on going, playing along with that. But these things y'all see, this thing it's explaining very clearly what they're talking about. But we're gonna keep going, because this is not even it. Let's keep going. Said title is further amended by revising Code Section 19:727 relating to a hospital program for establishing paternity as follows. Prior to the birth of a child to an unmarried woman in a public or private hospital, the hospital that provides perinatal services shall provide to the mother and the alleged father written material about administratively establishing paternity. See what I'm talking about? Administrative. See, this is what they did with me. This is where the trickery came in at. Because they don't tell you there's a difference between administratively and judicially. But we're gonna keep reading, because it's gonna talk about both of them. Written materials about administratively establishing paternity, which they did not give me no material that did that. They only told me that if my son was to have my last name, I got to do a paternity acknowledgement form. That's all they told me. And they didn't give me no material saying nothing about administratively establishing paternity. It says the forms necessary to voluntarily acknowledge paternity, which was the paternity acknowledgement form. That's the only thing they gave us. It had no details about nothing on it, no kind of signification. Nothing was attached to it. Where is it? So I have no signification was attached to the form at all. So the words that they used on there could easily mislead you to thinking something that's not there. Okay, you thinking one thing, and they're using words of art on the paperwork, and you signing on it, and you swearing it under penalty of perjury and all this old stuff. Keep in mind, as I keep reading, you'll see that even the name has a social security number on there. No living man has a social security number. So that further confirms that this was they were doing it administratively, which only deals with the legal name. It doesn't deal with the living man himself. Okay. Now let's keep going though. We're gonna go deeper, and all the wheels gonna be turning by the time I'm done. A written description of the rights and responsibilities of a voluntary acknowledging paternity. They did not have me. They didn't give me none of that. Okay. The differences between paternity and legitimation. They didn't give me none of this. They gave me none of that. And the duty to support a child upon acknowledgement of paternity. See, they're talking paternity. That's why when you do the paternity of acknowledgement, that's why they talk about child support when it comes to paternity. Is when it comes to that. But legitimation is what gives you custody rights. You can invoke your rights all these different times. Custody, visitation. Until you do that, you can't do none of this. It's told you that she get to exercise all the rights over the child. It said unless the father legitimates the child. If you don't legitimate the child, then this paternity acknowledgement form is not enough. Only thing you're gonna do, they gonna put your name gonna be on their radar when they go to talk about child support. So they can come to you for that. Okay, so that's the only thing you do. You don't give you no rights to the child at all. You might can, get away with, filing your taxes or some shit like that, getting a social security card or something. But some shit like that, that's about all you can do, but you're limited. You don't have no access to the child. So if she say you can't see the child, the courts ain't gonna do shit about it because you have not legitimated the child. And the opportunity prior to discharge from the hospital to speak with staff. See, they didn't do any of this stuff when I was at the hospital. Okay, The opportunity to speak with a staff either by phone or in person who are trained to clarify information. That's that signification right there. They will be the experts that they talking about. The experts that law says it's supposed to have. They go to experts. Okay, no experts. Nobody said nothing about this clarification of the information. And generally there are chicks that are in there, so they ain't give a damn about their father knowing shit. Say who are trained to clarify information and answer questions about administratively establishing paternity and judicially establishing paternity. See, that lets you know there's two different. We in the courtroom having judicial arguments. I'm the living man. I'm not the legal fiction. We're having judicial arguments in an administrative court. This is what we're doing when we go into these child support courts, because we know that child support cannot be presided over by a judge of the court. They got administrators in there, and so they're the one that signing these orders, and you having a judicial argument. And why you having a judicial argument? Because there's no signification attached to the paperwork. Nobody clarified to you the difference between judicial and administrative. You don't know that you having a living man argument about your babies, and you want to love on your child, you want to have access, you want to raise your child, my biological property, this and all this other stuff that some people are having too. Y'all having living man arguments, and they're having administrative proceedings. They're only dealing with the fiction. They're dealing with your legal name. That's why the paternity acknowledgement form has this social security number on there, because no living man has a social security number. Okay, this is why the birth certificates. We ain't gonna go off into the birth certificate. But bottom line is you're having the wrong arguments, and it's their fault too, because they have a more higher responsibility. As you see right here, it says especially. Where is it? Part C. Especially on the part of public officers, they have a bigger responsibility to make sure, because we in our private world, we chilling at home, but we get served paperwork, some business paperwork to be invited. They're gonna play their game with them. Their job is to make sure we know what the fuck they're talking about in their paperwork. That's why we having these arguments, and that's how they're able to label a lot of these guys sovereign citizens. And some of the shit when we trying as beginners, they call our paperwork gobbledygook and all this old crazy shit, because we trying shit the best way we know as amateurs. You know what I'm talking about? And calling them, they do that type of stuff. When you sitting here trying to argue the best way you can, playing a game that you don't know how to play. You're not trained to play the game. So when you're not trained to play the game, but they're experts at the game. Here we go with it. They are experts in such trade, they have a bigger responsibility to explain what it is that they're talking about with their paperwork, and they don't do that. And this is why we're having different arguments every single time when it comes to our kids. We're having judicial arguments because we haven't done anything judicially. That's dealing with a real judge. Administrative does not deal with a real judge. Okay? I'm gonna read this again. We're gonna continue. The opportunity prior to discharge from the hospital to speak to a staff either by phone or in person who are trained to clarify information and answers about administratively establishing paternity and judicially establishing paternity. Let's move forward. After the birth of a child to an unmarried woman in a public or private hospital, the hospital that provides perinatal services shall provide the child's mother and alleged father, if he is present at the hospital, the opportunity to execute a voluntary acknowledgement of paternity consistent with the requirements of Code Section 19746.1. File the signed voluntary acknowledgement of paternity with the state Office of Vital Records within 30 days of its execution, and provide the child's mother and alleged father copies of the signed voluntary acknowledgement of paternity. I think I showed y'all mine on a video previously. Like probably some years ago. Shit, I don't even show it now, but I did have one. But anyway, I still have it, but it's not necessary to show now. Okay, Said title is further amended by revising subsection D of Code Section 19743 relating to petition to establish paternity and genetic testing as follows. In any case in which the paternity of a child or children has not been established, the court, either on its own motion or on the motion of any party, may order the mother, alleged father, and the child or children to submit to genetic tests as specified in Code Section 19745. Such motion, if made by a party, shall be supported by a sworn statement alleging paternity and setting forth facts establishing the reasonable possibility of the requisite sexual contact between the parties, or denying paternity and setting forth facts establishing a reasonable possibility of non-existence of sexual contact between the parties. Appropriate orders shall be issued by the court. The court shall grant a party's motion unless it finds a good excuse for non-cooperation. Said title is further amended by revising Code Section 19746.1 relating to the name or social security number on the birth certificate or other record as evidence of paternity, and signed voluntary paternity, a voluntary acknowledgement of paternity as follows. And see, that's what mine was on there. Let's just keep going. The appearance of the name or social security number, social security account number of the father entered with his written consent on the birth certificate or a certified copy of the certificate, or records on the name of the records, on which the name of the alleged father was entered with a written consent from the Vital Records Department on another state or registration of the father, entered with his consent in the putative father registry of this state, pursuant to subsection D of Code Section 1911.9, shall constitute prima facie case. Shall constitute a prima facie case of establishment of paternity, and the burden of proof shall shift to the putative father to rebut in a proceeding for the determination of paternity. See, now they got you as prima facie. Now they calling you the putative father. You know what putative means? I'm gonna show y'all what putative means. Now they're labeling you as a putative. Alleged, presumed, supposed. Okay? Just so y'all know. I like to look up word, let y'all see it, instead of me just telling y'all what it means. Okay? So it's up to you to prove it. Okay? To prove these things. Are you using the paternity acknowledgement form? And see, keep in mind, say the name of the appearance of the name. That word appearance kind of stands out to me, y'all. When they say failure to appear, appearance, anyway, or social security number of the father. Keep in mind, both of those are written on the paternity acknowledgement form, and then it's sworn. You actually, you got it notarized. So they got you, with your consent, they use all this information. They use that information to label you as the putative father, the supposed, the alleged father, presumed. It creates a presumption. Okay, a prima facie establishment of paternity. It didn't say prima facie proof of establishment. It said prima facie establishment of paternity. And say the burden of proof it shifts to you, the putative father, the supposed father, the alleged father, to rebut such in a proceeding for determination of paternity. So, say when both the mother and the father have signed the voluntary acknowledgement of paternity in the presence of a notary public or other witness, and such acknowledgement is filed with the state office of vital records within 30 days of execution, and is recorded in the putative father registry established by subsection D of the Code Section 1911.9, the acknowledgement shall constitute a legal determination of paternity, subject to the the right of the signatory to rescind the acknowledgement prior to the date of support, the date of support, and any other adjudicating paternity or 60 days from the signing of the agreement, whichever is earlier. Now see that they're talking about the putative father registry. That lets you know that this is the status they've had me at when it comes to my son all his life, because of that paternity acknowledgement form. This is the only thing this does. When you sign the paternity acknowledgement form, you are deemed the putative father. That is the label they got you recorded in there. It's recorded in there as in the putative father registry. They recorded that once you did the paternity acknowledgement form, and they used that and they sent it there within 30 days. They got it recorded, and that's the status they had me at all these damn years. And I'm wondering why I haven't been able to get hold of my son, because I'm only the putative, the alleged, the presumed, alleged or supposed father. And until DNA is established, I'm gonna have that status anyway. That's the reason why, because I never had him legitimated. Okay, so let's keep going, because it goes deeper than that. Let's keep going. Let's see, where was I? Yeah, I think I said this part, which is earlier. Recording such information in the putative father registry shall constitute a legal determination of paternity for purposes of establishing a future order for support. See, so that's where they come at you for that, because you don't want on the birth certificate. Okay, and that's only dealing administratively. It's only dealing with the legal name. Okay, it ain't got nothing to do with you as a man. That's why they'll come, and this is part of the fraud too. When they use deception, when they'll say that they'll use fake like false allegations to make it look like you some type of abusive person, or you something that got something to do with your character. When this is purely administrative, and an administrative or legal name can't have these things. You know what I'm saying? It's not even a criminal case. So they're using these arguments to get you in your emotions, when the whole thing is purely administrative. So that's part of that's part of the fraud they use too. That's theft by deception. By definition, that's theft by deception. You might want to look up to that too. I'll say, okay, and order and other matters under Code Section 19751. Acknowledgement of paternity shall establish the identity of the biological father. See what I'm saying? So I'm the biological father of my son, but that paternity acknowledgement that I did, they say that established my identity. So they established me as, even though I'm the biological father, they got me recorded and recognized as the putative father. See what I'm saying? They got me. That's what it's saying. Acknowledgement of paternity shall establish the identity of the biological father, as such terms defined in Code Section 19722, but shall not constitute a legal determination of legitimation pursuant to Code Section 19722. See, so you don't get to exercise no rights. You don't get to, you got that. They got you as a putative father, but this is your real status, the biological father. That's a living man right there, because that biologically he was created from my loins. Okay, that's the living man right here. They got me as a putative father. Okay, recorded in the putative father registry. Got me recorded there. The name recorded there, and they only dealing with me on the administrative level, but it's not dealing with me on the biological level. That's where judicial comes in, when you're dealing with a real judge. Okay, now and they're saying that, and that can't be done. It can only be done through legitimation. Okay, now after 60 days rescission period specified in subsection B of this code section, the signed voluntary acknowledgement of paternity may be challenged by court only on the basis of fraud, duress, or material mistake. They say after 60 days. After 60 days rescission period specified in after 60-day rescission period specified in subsection B of this code section, the signed voluntary acknowledgement of paternity may be challenged in court only on the basis of fraud, duress. Now I got some more ammo right here too, because of this code right here. They didn't do that. They didn't do that at all, but I got a paternity acknowledgement form, and that's what's being used to keep me. Here I am thinking I got legal rights to my son, and I don't. I'm gonna use that against their ass in the future. But anyway, on the basis of fraud, duress, or material mistake of fact, that the burden of proof on one person challenging, with the burden of proof on the person challenging the acknowledgement. The legal responsibilities of any signatory, including child support obligations arising from acknowledgement, may not be suspended during the challenge, except for good cause shown. Okay, now let's see. Now, so if any of you inside these paternity acknowledgement form and it's after 60-day period, you can actually raise that. You can actually this code says it may be challenged in court only on the basis of fraud, duress. Now you can call them out on that fraud. Okay, that's theft by deception. That's swindle. That's a form of fraud. Okay, by swindle. I gotta look that up for y'all too. Swindle. Say to swindle means to dispossess someone of money or property, though through fraud or deceit. Okay, let's see. Theft by deception. So when it obtains a person commits the offense of theft by deception when he obtains property by any deceitful means or awful practice with the intention of depriving the owner of the property. So it's like this is fraud, okay? So these are types of fraud, you know. Anyway, keep going. We're gonna keep going, but now we see you can raise that up. So if you decide to go there with the paternity acknowledgement, you know, you want to challenge that thing after 60 days. Based on it, you have to use these here. It got to be under these here with the burden of proof, challenging that there. And if you're in Georgia, you can definitely use this right here because they were supposed to have that attached to that. They did not. And if you got a certified copy of that form, you can see, right? You can see on the thing that it don't clarify what the fuck these terms actually meant. Okay, so it'll be an open and shut case if there is no signification attached to it because you got the law to back up what you're saying. Okay, let's see. Good cause. Okay, a copy of a signed voluntary acknowledgement form shall be provided to any signatory upon request, as used. As used in this section, the term child placing. That's what I'm gonna skip on past that. Let's see, registrar, custodian, written application, certified copy of acknowledgement of paternity. And I guess I will read that a little bit. I'm gonna read that little part. Let's see, as used in subsection, the term child placing agency means an agency license as such pursuant Chapter 5 of Title 49. Legal custodian shall have the same meaning as set forth in Code Section 1511.2. They just reading the damn code section. Okay. 2. A state registrar or local custodian, upon receipt of a written application, shall issue a certified copy of voluntary paternity acknowledgement in that state registrar's or local custodian's office custody to the person who signed such acknowledgement and his or her guardian or temporary guardian. So now you see where you can get it from. You can actually get that from one of these. Let's see. Local custodian, upon receipt of the application, shall issue the copy. So it's a state registrar or the local custodian. Okay. The person whose paternity was acknowledged, you know, that's the child. If he or she is at least 18 years of age. The guardian, the temporary guardian or local or legal custodian of the person whose paternity was acknowledged. The living legal spouse or next of kin, the legal representative or the person who in good faith has applied and produced a record of such application to become a legal representative of the person whose paternity is registered. The court, a court of competent jurisdiction, upon its order or subpoena, any governmental agency, state or federal, provided that such certificates shall be needed for official purposes. The a member in good standing of the bar of the State Bar of Georgia provided that such certificate shall be needed for official purposes, and a child placing agency provided that such certificate shall be needed for official purposes. Now, let me see, where was I going to go to? Am I going to go to this part right here? Let me see. I'm gonna read and we're going to see. I think I probably showed most of what I was going to talk about. Damn, this video almost an hour long. I ain't never went this long. Said title is further amended by revising Code Section 19751 related to the order of support, visitation privileges, and other provisions as follows. 19751. The decree or order establishing paternity may contain any other provisions ascertaining the duty of support of the child by periodic or lump sum payments or any other matter in the best interest of the child. Let's see. Legal father is not. We already read this part. Okay, I'm gonna stop right there, y'all, because I think that's where I stopped at when I decided I want to make this video, because that was pretty. It lets you know that there are two different. Like I say, you guys, we have not just you guys. I have to been making two different arguments in these courtrooms, and here I am talking about she take my son from me, and I haven't seen him in X amount of years. She been doing this and shit. Like I say, I've been having a judicial argument in an administrative court, and a lot of us do that. We've been doing that for the longest and not realizing that there's a difference between the two. Your name is on the birth certificate, but that's only for judicial purpose. It's only for administrative purposes. It's not for judicial purposes. So this is what, and the only way you're going to get the judicial remedy is through legitimation. Administratively establishing paternity is just being on the, you're dealing with the legal fiction, you're dealing with the legal name, you're just doing a paternity acknowledgement form. And so only then are you going to be able to actually exercise your rights as a man when it comes to your kids. When it comes to your kids, and don't come get on my damn comments talking about kids is a baby goat, goddamn it, I'm talking about some damn children. Y'all know what the fuck I'm talking about. Stop overcomplicating everything. but bottom line is, this is the only way you're going to get to this type of jurisdiction, invoke that kind of jurisdiction, is when you go through the legitimation part of it. Okay, so we've been having the wrong arguments the whole time, the wrong fight. We have not been holding them accountable to signifying their terms. They have a duty to interpret all statutes, and all interpretation of statutes, they have to have a signification attached, and we got to hold them accountable to that. That's what they supposed to been doing in the first place. Okay, and they use this because they're operating some fraud. They doing this shit on purpose because they're breaking the law right there, because there's a law that said they're supposed to do it, and they breaking the law right there. Okay, so if they breaking the law, you got to hold them accountable to that. But anyway, I'm gonna get it off here, y'all. It's about 58 minutes in this thing. Damn, this is the longest video I ever did. Well, I feel like, never mind. Hey, I know some people be doing video, they be long as hell. But at least I've been kind of, I hit the ground running with mine. So, hopefully, y'all got that, helped y'all out a lot. I'm moving on the private side. I know I gotta be more confident. That's why I'm gonna put more videos like I was posting, because I gotta stay focused on my remedy more so than just kind of, constantly making sure I record, and being on the internet constantly. I'm on the internet studying, I'm applying stuff on the private side, getting things done on the private side. And so that's what I'm doing as I speak. So while I'm doing this stuff and you don't hear from me, believe me, I'm moving. So it ain't sitting around balling. I'm not balling up. Ain't nothing lost. Despite what you might hear, I guarantee you there's a fight going on in the back. Okay, so it's some furniture moving over here. So you best believe that's exactly what's happening here. So just keep on, just keep your eyes open and see what happens. Okay. So Hopefully y'all got something out of this, and then we'll see y'all in the next video. Jimbo, signing out.